This is a short video about my article, soon to be published in Regulation and Governance. The article is called Managing Dissonance, Bureaucratic Justice and Public Procurement. My name is Richard Craven. I'm based in the School of Law at the University of Sheffield in the UK. The research is part of a project funded by the Lever-Hume Trust. So the article concerns public procurement, and public procurement is central in public administration today. I mean, clearly, instead of acting as the provider of public services, the public sector, particularly in the UK, the public sector procures from the market, typically contracting with profit-seeking firms. I've worked on understanding the regulatory system on public procurement for a number of years now. And that's particularly the legal regulation of public procurement in the UK and in the European Union. As it currently stands, the UK's regulatory system is still very much based on EU law. But following Brexit, there are plans to change this. The UK government very recently consulted on transforming public procurement in the UK. So that's very much the regulatory backdrop to the article. In the past and up to this point, my empirical work on public procurement has tended to emphasise the importance of uncertainty in these decision-making environments. So these sort of environments like procurement departments in public sector organisations. So that's particularly around legal uncertainty. So for example, grey areas in legal texts. It's also uncertainty over whether potentially non-compliant conduct will be challenged. Will it be challenged by the European Commission? Will it be challenged by aggrieved bidders? So in the article, I want to develop our understanding of how procurement decision-making is organised. There are notable exceptions, but in general, I would say that this has been under-theorised. And so I think it's a useful conversation for academics to be having. So to look at the organisation of decision-making in, say, procurement departments, in the article I engage with two theoretical perspectives, and both of these theoretical perspectives are based around the idea of situated justice. I use Jerry Mashaw's pioneering work on administrative justice, which is found in his book Bureaucratic Justice from 1983. In Bureaucratic Justice, Mashaw puts forward three decision-making models, so three ideal types. And those are bureaucratic rationality, professional treatment, and moral judgment. I then tried to build on Mashaw's theorising by interpreting it with an economic perspective. So I interpret it in conjunction with the economic sociology of Luc Boltanski and Laurent Thévenot. Boltanski and Thévenot, back in the 1980s, at around the same time that Jerry Mashaw was working on bureaucratic justice, well, they put forward an analytical framework based on orders of worth. Very similar to Mashaw. Here you have a variety of orders of worth, such as the market order or the civic order. They're the most important for my purposes. And these different orders of worth, they give actors in decision-making environments, they give actors a lens in which to evaluate a situation. And what they say is that actors will flit in and out of these different orders of worth according to the situation at hand. To illustrate how these two theoretical perspectives can operate together, I then go on, having set them out, I go on to sort of analyse a prominent controversy in EU and UK public procurement law, policy and practice. And that's around the scope to pursue labour wage objectives in public contracting. So specifically, I look at the scope to pursue statutory minimum wage objectives, and I also look at the scope to pursue non-statutory living wage objectives. In using this sort of new or sort of enhanced analytical framework, in this article, I think I highlight the role of dissonance. The sociologist David Stark defined dissonance as being where diverse, even antagonistic performance principles overlap. Readers of Regulation and Governance may be more familiar with Julia Black's sort of reference to the idea of the battle of the norms. What we find is that procurement decision makers must contend with different notions of what the right thing to do is, what the just thing to do is. And this is resolved in different ways depending on the situation. And actors must necessarily shift in and out of different modes of justification in order to arrive at pragmatic outcomes. So to conclude, this article puts forward a fresh interpretation of Mashaw's bureaucratic justice, and the interpretation is grounded in a recognition of the significance of conventions and Boltanski and Thevenot's orders of worth. There's a lack of academic work into the administrative justice dimension of the contracting state, and I hope that this article can be helpful in spurring on research in this area. Thanks.